Elonis versus United States is the Facebook rap threat case involving a question of how to construe the interstate threat statute, Section 875C, involving punishing transmitting a threat. It involves an individual who posted on his Facebook status updates involving what could be construed as threats against his wife. He at one point threatened to go to an amusement park or go to a school and perhaps commit a violent act at the school. He argues that it was simply he was joking around. He's an aspiring rap artist, and in fact, during his status updates, he's talking about true threat jurisprudence and about what he's doing is all First Amendment protected. It's sort of an odd situation, very meta here. It's sort of what's a true threat of an individual posting about what is a true threat. The first issue in the case is whether there's a subjective intent requirement. If he thought what he was doing was not a serious threat, do you interpret what is a threat based on what a reasonable person would think, or is it what the individual subjectively believed? Can you have an accidental threat is the question. A big issue, I think, online, because you read something online and you don't know what the person was thinking. Are they really intending that as a serious threat, or was that just a joke? It can be hard to tell from the context. And then if the court construes the statute as not requiring a subjective intent requirement, the next question is whether the First Amendment allows that, whether it's the First Amendment prohibits a negligent threat statute, effectively. So there's the statutory question, and then also the First Amendment question if the court does not resolve that case on statutory grounds. And I should add that I gave a very small amount of assistance on the defense side for that case.